Good afternoon and welcome to our webinar Dismissal during COVID-19. What are your options? We are Priscilla de Lede and Eileen Pluim from Russell Advocaat in Amsterdam. We are both lawyers specialized in the labor law, and we are part of the Corona crisis team that has been set up after receiving a lot of questions from entrepreneurs regarding legal problems that they are facing due to the COVID-19. And we assist many entrepreneurs who run into serious problems due to the COVID-19, and they're asking questions regarding employment contracts, changing of employment conditions, options to dismiss employees, actually as a solution to solve their problems. And today we discuss what options might be possible for your company. And therefore we will discuss the changing of employment conditions, the options to dismiss employees, and the role of the Works Council. And as a remark, additional questions can be asked via the chat, and we will try to answer them during the webinar. But if that's not possible, you can always send a message to us or contact us afterwards.
So first we'll get into changing employment conditions. So when we're talking about employment conditions, you can think of salary or holidays or even lease car. And in principle, you are bound to the employment conditions that you've agreed upon in the employment contract. However, there are some situations that you can actually change these employment conditions during the contract. The first one, being also the easiest, is changing with the consent of the employee. So you propose a change to the employee and he or she gives his consent, especially during the difficult circumstances at the moment due to the Corona crisis. It is of course possible that the employee is willing to agree to a change if he has the option between maybe a salary reduction or another change to the employment conditions and redundancy or bankruptcy of the company. Then the choice is sometimes easily made by the employee and he opts to change the employment conditions. However, not always will an employee agree to this proposal to change the employment conditions. And in that case, it is sometimes possible in two situations to change the employment conditions unilaterally. So if you have an amendment clause in the employment contract, it is possible to unilaterally change the employment conditions. This clause that needs to be included in writing, either in employment contract, a collective labor agreement, or personnel handbook. And you can make use of this clause if you have a substantial interest to do so. And this interest is so heavy that the interest of the employee has to be set aside for it. And then the third option is when no such clause has been agreed in writing. You can make a reasonable proposal to your employee and he has to agree to that proposal based on good employeeship. If there are changed circumstances in the workplace, you have made a reasonable proposal and acceptance can reasonably be required from your employee. The second situation, so when you have an amendment clause in the employment contract, that's mostly focused on making collective changes to employment conditions for all your employees together. While the third option, by making a reasonable proposal, is mostly based on an individual change of the employment condition in an individual case. So there have already been some case law on the changing of employment conditions due to the Corona crisis. There have been a couple regarding salary reductions. So for instance, if we look at the first court case, in that case there was a 50% reduction of the salary payment, and the other 50% has been postponed until further notice. It was someone that had a restaurant in the city center of Amsterdam, and of course due to the government measures this restaurant had to be closed at some time, and the subsidy received by the government that wasn't sufficient enough to cover all the labor costs. So the employer decided at that moment to proceed with only 50% of the salary payments, and the other 50% would be suspended. And the employee, he did not agree, so he went to the court claiming the other 50% of his salary payments, and the court said that he was in fact entitled to the other 50% as well. So the changing of employment conditions was not allowed in that case, and the court considered that although the coronavirus caused an emergency situation for that employer, the financial situation was very tight for him, which could give him reason to change these employment conditions. It was not allowed in this case because it was 50%, which is a significant loss of income, so it caused significant financial problems for the employee, and second, it was not discussed with this employee at all. So that is very important in the eyes of the court, that there has been some consultation with the employee. Also looking at the second court case regarding the 25% reduction in salary, that eventually was also not accepted. In that case, it wasn't sufficiently substantiated why it was necessary to make this change. There has also been some court cases regarding the obligation to take holidays. The one mentioned on the sheet, that in that case, the employees were forced to take 20% of their holiday before a certain date. The employee did not agree to that. So in that case, it was also not allowed. The court he considered that in this case, the employee only referred to the corona crisis as a substantial interest to make a change to the employment conditions, but just referring to the corona crisis on itself is not enough. You have to substantiate that due to this corona crisis, it has had some effect on your company, significant financial impact, and you have to prove that to the court, and in that case, you can reasonably change the employment conditions, but just referring to the corona crisis in itself is just not enough. So there are a couple of things that we can take from these court cases. So the first one being referring to the corona crisis in itself, that is not enough. Then of course you need to consult your employees, have a meeting with them, explain why it's necessary to change the employment conditions. And then also keep in mind that changing primary employment conditions such as salary is more difficult than changing, for instance, lease car or something like that. And also what is of importance to judge is this a temporary measure or is permanent, and has there been offered any compensation in the future? So that can all make it more more possible to change the employment conditions.
So we just discussed the options to change the employment conditions, and sometimes it's not sufficient for a company to only change the employment conditions, but to continuate your company, you will have to dismiss employees. And that's what we're going to discuss now. First, we'll start with the general dismissal law, the UWV proceedings and legal proceedings, the options to conclude a settlement agreement, and the dismissal on the spot. Well, first of all, a remark that Dutch labor law does not change during COVID-19, it stays the same. So that means we have a difference between temporary and permanent contracts. Temporary contracts, they will end as of the date as agreed upon in the contract, and it's not possible in principle to terminate the employment contract prior to the end date unless this is explicitly agreed upon in the contract. And then the normal or the regular dismissal law applies. That also applies to permanent contracts. And Dutch dismissal law requires from an entrepreneur or employer a reasonable ground for dismissal, and the ground determines the route to take as an employer, because there are two routes. And the first one is the employee insurance agency proceedings, also called the UWV. That's a governmental authority that carries out tasks like insurance, employee insurances, and employment benefits, etc. And you go to the UWV in case of financial, economic reasons or the long-term illness of an employee. And the second way is legal proceedings before the court. That's in case of personal reasons related to the employee, for example, underperformance or a disturbed relationship, and we will come back to that later. So there are a few rules that applies both to the UWV proceedings and the legal proceedings. First, there's the obligation to investigate whether an employee can be transferred to a suitable position before you're going to terminate the employment contract. And if there's no suitable position available for the employee, you can start legal proceedings or UWV proceedings. And as employer, you always have to take into account a notice period. This means that you will have to take into account a certain period based on the length of the employment. So for less than 5 years, it's a 1 month notice period. For 5 years or more, but less than 10 years, 2 months. 10 years or more, but less than 15 years, a 3 months notice period. And if an employee has been employed for 15 years or more, you have to take into account a notice period of 4 months. And the notice period has effect from the end of the calendar month. Then the transition compensation, because each employee whose employment has been terminated on the initiative of the employer is entitled to a transition compensation. And this also means that when you do not extend a temporary employment contract, the employee is entitled to a transition compensation. And the accrual starts immediately from the first day, and the amount is 1/3 of the monthly salary per year of service. So that means that if you have an employee employed for 3 years, the transition compensation will be equal to a 1 month salary. Please note that also in case of bad financial circumstances, you are obliged to pay a transition compensation. So if you want to terminate or need to terminate an employment contract during COVID-19 due to bad financial circumstances, you are still obliged to pay a transition compensation to the employee. Furthermore, an employer is not obliged to pay a transition compensation in the event of a termination with mutual consent in case of a settlement agreement, and we will come back to that later. And the transition compensation will not be due in three situations. And I would like to make a note that the termination is if the termination is a consequence of a culpable act or negligence of the employee, the transition compensation will not be due. But if we're talking about dismissal on the spot, that we will also discuss later, it might still be possible that you will have to pay a transition compensation. So the first way, that's the UWV proceedings in the event of mostly financial economic reasons. That also includes a reorganization. So if you would like to or need to terminate an employment contract of an employee due to the COVID-19, and so it's a reorganization, you have to file an application with the UWV to obtain a dismissal permit. That's the proper way you have to follow. And that means that you have to substantiate in detail your economic reasons. So you have to provide the UWV with figures, and you have to make clear that you have a turnover loss, etc. It's very strict, and you have to prove that there is no suitable position available for the employee. And normally such UWV proceedings take 4 to 8 weeks, and it will depend, of course, on what the employee has to say, because when you have applied for such a dismissal permit, it's up to the employee to give his view. And you have to take into account that in case of interchangeable positions that become redundant, the reflection principle applies, and it means that a certain ranking applies that determines which employees will become redundant. And so the last in, first out principle applies. If the dismissal permit is granted by the UWV, you can as employer terminate the employment contract within 4 weeks. And if the employee does not agree with this termination of the contract, he can start legal proceedings within 2 months. And on the other hand, if the dismissal permit is not granted, the employer can submit a request to the court within 2 months so that the court then deals with the request to terminate the employment contract. The last point regarding UWV proceedings, it might be possible that there is a collective dismissal. This means that you as an employer intend to terminate at least 20 employment contracts within 3 months of time. If that is the case, we call it a collective dismissal, and the Collective Redundancy Notification Act applies. So as an employer, you will have certain extra obligations like the consultation of the interested employee associations and the notification of the UWV. And you really have to take into account and to comply with these obligations, because if you do not do so, the employee can start proceedings at the court, and the court might nullify, for example, the settlement agreement that has been concluded. That's very important because termination of at least 20 employment contracts also includes settlement agreements. So it's not only terminations via the UWV or the court, but also the settlement agreements that you conclude with the employees.
So the other option besides going to the UWV is going to court, and that is, as Priscilla also mentioned, in the event of personal reasons. Even during the Corona crisis, there might be grounds to terminate someone based on those personal reasons. There have been quite a lot of measures taken by the government. For instance, it is now very strongly advised to wear face masks in shops, and that urges you to make all kinds of choices. So, for instance, if you are a shop owner, do you oblige your employees to actually wear a face mask while working? And the same goes to working at home. That's also strongly advised, but is that possible at your work to work from home or not? Home quarantining, how are you handling that? So a lot of choices that have to be made by you as an employer. So basically that makes a sort of set of rules for your employee that they have to follow. Every employer has their own set of rules based on how the company works. And we would say that it would be best to make this into some sort of COVID-19 policy. So that's something we strongly advise, so that it's very clearly communicated to your employees what is allowed, what is expected, and what are the consequences if they do not follow this protocol. And that is where the legal proceedings are of importance, as well as a dismissal on the spot that will later be discussed. Because if your employees do not follow the COVID-19 protocol, there might be a personal ground to dismiss an employee. So you have to go to the court and ask the court to terminate the employment contract in that context. And please note that in that context, you will need to provide an extensive file to the court. So the most obvious grounds for dismissal in that case are underperformance or a disturbed working relationship. Well, in either case, you have to come with an extensive file that shows that there is in fact underperformance or a disturbed working relationship. In the light of dysfunction underperformance, it is also necessary that you show that you have made your employee aware of the underperformance by him or her, as well as that you have offered him or her a personal improvement plan, so that you have helped the employee to improve, but that hasn't worked out and the underperformance is still continuing. Please note that the court might award a fair compensation to the employee if you are culpable for the dismissal, the termination of the employment contract. So before, we have discussed this court case in which there was 25% reduction in salary that was proposed to the employee, and he did not agree to this. And in that case, the employee started bullying the employee. So for instance, he was given an official warning for no reason. He was placed out of his team, etc. So that is an obvious case in which the court might rule that you have to pay a fair compensation because you have actually pushed your employee to this point that termination of the employment contract is needed. So please be aware of that. So the third option for dismissal is the settlement agreement. That basically means that your employee consents to his termination and you lay down the arrangements of the termination of the employment contract in the settlement agreement or termination agreement. It needs to be in writing, that is important. Something we've already discussed before, is a severance payment needed? Does that need to be included in the agreement? As Priscilla mentioned before, transition compensation is not mandatory to be provided when you agree on a settlement agreement. However, it is not uncommon because if it is very easy for your employees to just say, okay, I'm not going to sign the settlement agreement, and in that case you have no other option than to initiate UWV or UWV or court proceedings. And if those proceedings are successful and you get to terminate the employment contract, you still have to pay the statutory transition compensation. So therefore, in most of the time, severance payments equal to the amount of the transition compensation, or even higher amount, is included in the settlement agreement. A tip we want to give you is that you can submit a provisional request for dismissal to the UWV. So basically you hand in a request to the UWV, but it's only part of the request for dismissal due to financial reasons. And then you ask the UWV to grant you a 2-week period to negotiate a settlement agreement while also continuing these UWV proceedings. So you have 2 proceedings going on at the same moment, but you have sort of a pause in between that allows you to agree on a settlement so that you don't actually have to finish the UWV proceedings if you can agree on a settlement agreement. And that saves you quite a lot of time and therefore also money that you otherwise would have to spend on finalizing these UWV proceedings, because as Priscilla said before, you have to substantiate with financial numbers, etc., why it's needed to dismiss this employee, and that can take up quite a lot of time. Then third thing that we have to take into account for a settlement agreement is the reflection period. It's very important to understand that once your employee has signed the settlement agreement, there's actually a 40-day reflection period. So within these 14 days, your employee can say, well, I've made a mistake and I want to withdraw my signature, and then the settlement agreement is off the table. So there's a 2-week period that there's uncertainty whether the settlement agreement is actually valid, but after that period of time, the termination is complete. So the final way of termination is dismissal on the spot. This is for a strict number of cases. Only when there is an urgent reason for dismissal, then you can just terminate the employment with immediate effect without giving a notice period. So first off, there needs to be an urgent reason for instance, theft by your employee, but also during coronavirus, there can be a reason for urgent reason dismissal on the spot. For him or her not following the COVID protocol, and it is so bad of a mishap that it provides an urgent reason. It's very important that you give this dismissal to your employee at the soonest moments possible. So you have to inform him as soon as possible after the urgent reason has arisen that he will be immediately dismissed. And furthermore, you have to provide him the urgent reason as soon as possible so he or she knows why she is being dismissed. So with regard to dismissal on the spot, there's also been a few court cases. We have listed 5 on the sheet. Well, if we, for instance, look at the failure to respect the 1.5 meter distance, in that case, there was a COVID policy by the employer that said you have to respect the 1.5 meter distance, as also instructed by the Dutch government. But in that case, not only the employee failed to respect that the rule, but also other employees. So the court says, how can you act in the one case but not towards the other employees? So there was no strict enforcement of this rule, and that is why it failed. Well, if we look at the 5th example, opening of a restaurant against government measures, in that case, the Burger King was opened by the employee while strictly being instructed by the employer not to open the restaurant due to the government measures that were taken. And in that case, the court ruled there is in fact an urgent reason because there was a very clear message from the employee how the employee had to act, and he did not follow that instruction. So it's very important that there's a very clear rule that has been enforced towards all employees equally. Very important to understand as well is that the financial distress, the emergency situation that arises due to coronavirus in itself does not provide an urgent reason. That has also been ruled in court proceedings. That's the 4th one on the sheet.
Yeah, and there are also the other court cases on the sheets regarding dismissal on the spot. The first one mentions the challenging public COVID-19 policy, and that's about a civil servant, and she expresses her concerns regarding the COVID-19 policy, and she did that on Facebook, so she did that on public, and in that case, under that circumstances, the court ruled that it was a reason to dismiss the employee on the spot, because the employer does not have or did not have the trust anymore in the civil servant. So it is possible to dismiss someone on the spot. But if we're talking about, for example, the quarantine at home, it might be a little bit more difficult to dismiss an employee on the spot. In that case, the employee and also his family, they stayed in quarantine at home. And the employer, he asked the employee to come back to work actually, and he gave an official warning. And if at the moment that the employee did not come back to work, the employer dismissed the employee on the spot. And in that case, it has to be keep in mind that when you are talking about quarantine and the refusal to work, that it is about, or you have to take into account whether it's possible for a company that the employees work at home, what kind of company is it, and did the employee refuse to work before, also prior to the COVID-19, etc. So if in general, if we're talking about the dismissal on the spot, whether it's possible to dismiss an employee, you have to keep in mind that when an employee, that he goes to the court to contest his dismissal, the court will always take into account the personal circumstances, the whole picture, all the personal circumstances of the employee. How long did the employee work at the employer? Have there been any more situations like this, etc. The last point of our webinar is what the role is of the Works Council in this whole process, because when you have as an employer or you have a company with at least 50 employees, you are obliged to establish a Works Council, and that Works Council has certain rights, for example, the right to be consulted. That's about major decisions of the entrepreneur, and a lot of measures taken during the corona crisis, they may have far-reaching consequences for the employees, such as a reorganization or even partial termination of business activities. And as entrepreneur, you will have to request the Works Council for advice regarding such an intended decision. And the second important right of a Works Council is the right of consent. So that's regarding certain regulations, for example, working from home or monitoring your employees that are working from home, adjusting working hours, etc. You will have to ask the Works Council for its consent. And you will also have they also have the right to be informed and the right of initiative to influence the policy of the entrepreneur. So they have very important rights that you will have to take into account when you intend to take a decision such as a reorganization. Well, taking into account everything that we said during this webinar, the conclusion is that labor law stays the same during COVID-19. So if you would like or need to or intend to change the employment contracts or so the employment conditions of employees, or you would like to dismiss an employee, you will have to comply with Dutch labor law. And as we have seen, the coronavirus itself does not constitute a reason, for example, changing the employment conditions or a dismissal. You will need a reasonable ground. You have to substantiate all your reasons to do that. And therefore we advise to draft a very clear COVID-19 policy. So how does it work when employees travel to an orange travel restriction country, and when are employees supposed to quarantine at home, and what sanctions can you impose or may you impose as employer when your employees does not comply with your policy. You have to strictly lay down such a policy. It has to be clear for the employees what is expected from them, and of course you will have to consistently enforce the policy. And if you have any further questions regarding the change of employment conditions or regarding dismissal or other corona-related questions, you can of course send us a message or contact us. And thank you for attending this webinar.